Now, in such a case, it is recommended that the parties must come up with a genuine pre-estimate of losses as to what happens if one party breaches the agreement. What should be a genuine compensatory figure, so as to speak, that in case it is proven that a breach of agreement has taken place, the other party must pay, the party who breaches the agreement must pay the other party as compensation for the said breach. Now, it is very important that this is a genuine pre-estimate, because whatever the estimate provided for in the agreement, it also is required to be proven that the loss has happened, and only in cases where it is very difficult or impossible for the courts to come to a conclusion as to what should be the figure of such compensation. In that case, of course, the courts will take the pre-estimate as the final amount which needs to be awarded, but otherwise, that's the pre-estimate is taken as the upper limit of what the court should and would grant in such a particular case. Parties also can provide for limitation of liability, saying that in any case, even if there is a breach or in any event whatsoever, the liability of one particular party under the agreement shall not exceed a particular amount. So that is also, I think, a good practice to incorporate. Now that the breach has happened, what should the parties do? So that takes me to the dispute resolution mechanism that a contract should provide for. In default of the mechanism, of course, the good old civil courts would come into picture. But otherwise, the parties can also decide upon an alternate dispute resolution mechanism, and the most used or the most important among those is arbitration. This is when the parties do not go to courts per se, but they go to an arbitrator which they mutually decide, and the arbitrator will adjudicate upon the dispute and then pass an award. That award is as good as the judgment passed by a civil court and can be executed by a civil court as well. Apart from that, there are tribunals, and as far as businesses are concerned, the most important among that is the NCLT. These, of course, pertain only to companies as of now, and there's a specific act called the Insolvency and Bankruptcy Code, which provides for resolution, or it provides for it provides for companies specific reliefs as far as their disputes are concerned.